Hi everyone and welcome to episode 9. I thought that I'd brighten up a very wet and miserable afternoon in the Barbican by thinking about shopping. More specifically, I want to look at what the proposed amendments to the Use Classes Order might mean for retail development. The amendments are due to take effect this coming Tuesday, the 1st of September, and hopefully we'll also get the update to the PPG that's been promised then as well. From a retail perspective, there are two proposals that are principally relevant. So first of all, Class A1 shops, together with the other A-class uses and also Class B1, is of course to be replaced from the 1st of September by a single new Class E, Commercial, Business and Service. There will also be a new Class F2 local community, which includes use as a shop mostly selling essential goods, including food, to visiting members of the public in circumstances where 1. The shop's premises cover an area not more than 280 metres square, and 2. There's no other such facility within a 1,000 metre radius of the shop's location. Now, the first problem with this is that the regulations don't actually appear to say that if a shop falls within Class F2, it's excluded from the broader commercial Class E. It's very clear from the explanatory memoranda and the impact assessment for the regulations that Class F2 shops are meant to be protected because of their value to the local community, so they're supposed to be carved out from the commercial E-class, which includes all other shops and also things like offices and gyms. But I can't see that that point is actually spelt out in the legislation. Now, of course, you might say, well, come on, it's completely obvious, which I wouldn't disagree with. And it's true that there are principles of legislative interpretation that would also support an interpretation of the amended Use Classes Order, whereby if a shop is in Class F2, it can't also be in Class E. The problem, though, is that Regulation 7, on the face of things, indicates otherwise. Regulation 7 says that if a building or land is being used as a Class A1 shop on the 31st of August 2020, then from the 1st of September 2020 it is to be treated as if it's being used for a purpose specified within Class E, which doesn't leave any room for Class F2 to apply to existing shops at all. Anyway, assuming that the courts are in due course willing to overlook what seems to me to be simply an infelicity, I think is the polite term, in the drafting of the regulations, Class F2 throws up a number of points. The first is that it has to be a shop mostly selling essential goods, including food, to visiting members of the public. Now, wisely, in my view, given how difficult it would be, there's no attempt to define essential goods, so no doubt there'll be plenty of arguments about that to begin with. The next question is, what does mostly mean? I don't think that it's necessarily safe to assume a straightforward interpretation, as meaning that 51% of the shop's stock must be essential goods. Bear in mind what the courts have done with concepts such as likelihood in other contexts, such as the EIA regime. Even if the straightforward interpretation is the correct one, the next question is, can a shop dip in and out of Class F2 depending on its stock? So if 1 week it offers an unusually large quantity of non-essential goods for sale, does it then fall out of Class F2 and into Class E? If that is the right approach to the analysis, then how is the local planning authority supposed to keep tabs on that? It seems highly impractical, but there's no indication yet that the analysis should be done differently, for example by considering the shop's offer over a longer time frame, such as 6 months or a year. Also impractical, I think, is the aspect of the Class F2 definition whereby there has to be no other such facility within a kilometre radius if the shop is to fall within Class F2. Now, presumably that means no other Class F2 shop within a kilometre radius, but that means that a shop could find itself taken out of the broader, more flexible commercial Class E and drawn into the more restrictive Class F2 simply because a neighbouring shop has closed, or even because a neighbouring shop has changed its offer and is no longer mostly selling essential goods. Operators of shops that would fall into Class F2, save for the existence of an other such facility within a kilometre radius, will want to keep very close tabs on what their neighbours are doing. From a commercial perspective, the uncertainty around this seems to me to be undesirable. The final point that I have on Class F2 is that I'm simply not convinced that it will be very effective in practice. The government's perspective, it seems, is that it's protecting Class F2 shops because of their value to the local community, but I can't see that there would necessarily inevitably be a material change of use if a Class F2 shop were to change its use to a normal Class E shop, particularly given that a shop can apparently fall in and out of Class F2 depending on factors such as what neighbouring shops are doing and what stock it's carrying. So in reality, there might, on the specific facts of a particular case, not be anything to stop a Class F2 shop from changing into a Class E shop without needing planning permission. Bear in mind, of course, that just because something's in a different class within the use classes order, it doesn't mean that there will be a material change of use if you change use to that class. The use class order's effect is simply to confirm that changes within a class will not be development. So those are a few initial thoughts on the retail aspect of the proposed changes. I'm sure there'll be much more to say on all of the amendments in due course, but in the meantime, thanks for tuning in and take care.